In the justice system, ladies and gentlemen, truth doesn't always come down to what people think. It comes down to what the law actually says and how policy puts that law into action. Welcome to the Teske Brief. I'm Steve Teske, retired judge, and this is where we separate myth from law and policy, cutting through headlines, assumptions, and talking points to get to what the law really is, how it works, and why it matters. Now, usually on the Teske Brief, we break down legal issues piece by piece, case law, statutes, and the policies that shape outcomes. But today, we're doing something a little different because sometimes the best way to understand how law and policy actually work is to hear from the people who are applying it every day on the front lines of the justice system. And today, I'm joined by someone who not only understands the law, but has spent years shaping how it's experienced by families, children, communities. It's my pleasure to welcome Judge Geronda Carter, a Superior Court judge from the Clayton Judicial Circuit in Georgia, where I also had the honor and privilege of serving on the bench. And for those of you who are listening and you live outside of Georgia and you're not familiar with Clayton County, let me just say that it's in the metro Atlanta area on the south side. The Clayton Judicial Circuit encompasses the entire county of Clayton. And probably most people will be familiar with it, though you may not have known it at the time if you've flown in to Atlanta to maybe make a connection or to visit Atlanta, because it's the world's busiest airport and it is located in Clayton County. Now, Judge Carter has built a reputation for innovation, particularly in how courts engage with families and address the underlying issues that bring people into the system. From her work with parental accountability courts to her thoughtful use of technology to increase access and participation. In this conversation, folks, we're going to explore not just what the law says, but how leadership on the bench can reshape how justice is delivered. Judge Carter, welcome to the Teske Brief.
Hi, I'm so glad to be here. Thank you for having me.
Oh, it's great to have you here, not just as a colleague from the same circuit, but as someone whose work is pushing the system forward. And I've been, by the way, on the front lines witnessing your judicial leadership. Hence why I am so excited to have you on my podcast, the Teske Brief. So let me ask you this. We'll just kind of jump right into it, Judge. I want to talk about your path to the bench. You know, you began your service in the Clayton Judicial Circuit in 2006, but your journey started much earlier at Spelman and the University of Miami. What was the spark, okay, that led you from a background in psychology to a life of judicial service?
Well, actually, I began my service in Clayton County in 2005 as the presiding magistrate court judge. And the magistrate court judges at that time were all also, if we had the years in, were designated superior court judges. But that spark you mentioned came around 16 years old. It was following an incident where I witnessed and believed a lawyer to be unethical. And so it was from there that I decided that I wanted to go to law school and become an attorney. Being a judge was not on my radar at the time. And the subject of psychology was of interest. So, that's the degree I pursued. I have some who tease and say, well, that was the easiest one to get to law school. But it was later on down the road where the call to the bench, was acknowledged and, as you know, ultimately fulfilled.
You know, I find that very interesting that, I mean, your inspiration, okay? Most people are inspired, like, for example, for me in the 1970s, during summer breaks when I was a teenager, my mom and dad would send me out to Tucson, Arizona. That's where her side of the family resides. And, I grew up in my early childhood there, but was raised mostly, in Clayton County the rest of my life and my career. Of course, as you know, I retired back there, and but my point is, when I went out there in the '70s, my uncle had just graduated from the University of Arizona Law School, got a job as a prosecutor there in the county attorney's office in Tucson, Arizona, and I would ride to work with him in the morning. And that's what inspired me because I'd go in the courtroom, I'd see the courtroom. But you judge, it's because you saw something that was and experienced something that was unethical. Can you? I can't let that go. That's there's something about that that's like even more inspiring to me and really significantly impresses me. Can you tell me
Well,
what is it? You don't
yeah.
have to get into the detail of the unethical conduct, but just
Uh-huh.
more about you and how something unethical could drive you to be in this profession.
Yeah. So, well, it was so disturbing because of the effect that it had on my family. Okay. So it had a direct impact on my family. And I thought, well, it just can't be my family, that this is happening to. And so let me enter into this profession and make sure that it doesn't happen to any family that I encounter. And so I think that, the effect that it had on me is what it drove really deep, right? And so it gave me some additional motivation. I mean, and then coming from the background of where my parents at least did not have a higher education, but they were ready, right? They were positioned on ready to give us all the opportunity if we wanted to.
Is this kind of like in trying to your way, looking ahead of forging a path to try to right a wrong?
I believe so, though I knew that there was nothing I could do, right, to change the circumstances, of what occurred to my family. I knew that what I didn't want to happen, I wanted to be a part of the change, right? And since I knew that I wanted to pursue a higher education. I was like, okay, well, that's a good career. And then I was exposed in some programs that were provided to me from being an at-risk student to, working during the summer. I worked at the Justice Court
Mm.
for, I believe, 2 summers there, and I did 1 summer at the youth court. Um, Interning. And I saw at that time at the youth court, and this is already after I had that drive and motivation in me to be a lawyer, I got to see the first African American female um, lawyer in juvenile court. And it turns out that she had gone to Spelman. So,
Mhm.
there's another tie in there, to Spelman. Um, but I'm glad I was exposed to those things. I'm glad actually that I was able to witness that injustice that occurred because again, it's ultimately what propelled me to where I am today.
Yeah, and when I asked the question, I wasn't thinking at all about righting the wrong that happened in your case because you still had to grow up some more. You still had to get on that path.
Yes,
But it's
yes,
the fact that what happened to you had said earlier, this could be happening to other people.
yes,
Wow. I know that you hold a doctorate of theology. Okay. So my question is, I can't help it, but it just begs the question: how does your spiritual foundation inform your judicial temperament? Particularly your commitment to applying the law. Let's say maybe without fear, favor, affection, or regard to subjective variables.
yeah. So, um, my seminary studies didn't come till until over a decade of time on the bench. If you include the magistrate time. However, my personal relationship with God started when I was a young child, right? And it is God that I fear, not man. I'm grateful for the confidence, the voters placed in me by electing me to office. I've watched various judges, and while most of them do not appear to be beholden to a party that appointed them. Some of them are. And that, for me, is a sad scenario. When a judge or justice is willing to legislate from the bench, it is dangerous and it threatens the independence of the judiciary. And so the only thing I can imagine is that the judge who is willing to do those things fears man more than God. And that's my perspective on it. And from what I know and have studied about God, that's a dangerous way to live this life. I like to sleep at night, so I try and take care that my actions are decent and in order, if you will. It's God's people, our brothers and sisters, that as judges we are presiding over. You know, I
Yeah,
believe that we will be held accountable for
absolutely.
what we
Yeah,
do and what we don't do when we should do, you know?
yeah.
Um,
But so let me ask you this: um, focusing on your role as a superior court judge, okay? Um, you know, you are right now the longest active sitting judge in your circuit. You know, how have you seen the nature of, let's say, justice itself? You know, the concept of justice evolve in Clayton County over the last couple of decades.
and I know you know this. Um, Clayton County has always been able to do more with less, but now it's catching up. It's catching up with us, right? The doing more with less for decades, it's catching up. You know, when I arrived to the Superior Court bench in 2007, because though elected in '06, you start at the beginning of that following year. There was only four of us, and a great amount of time was spent trying to convince the state of our circuit's need for a fifth judge. And by the time the fifth judge was secured, we had a caseload large enough for nearly seven judges. It's been 10 years since our circuit received the fifth judge. Other changes occurred, and there, were learning curves and things that you expect with change, and that's fair. But when you lose institutional knowledge, such can cause a setback or two. I'm grateful, to our current Clayton County delegation members who have worked hard to secure our circuit an additional judgeship, but whether it happens will be determined by if funding, is actually secured. So the focus when I think about Clayton and justice, evolving, I can't help but think about the level of work expected, of the five of us.
But there's another challenge I want to talk about. You
Hmm.
had mentioned, okay, that it saddens you when you see self-represented litigants, or what we call pro se, unrepresented by counsel, when they come into court, they don't know anything about the law, but they believe that you have the discretion to do what the law does not permit. How do you navigate that delicate, like I call it the empathy gap, okay?
Hmm. Okay.
Providing a fair hearing to someone without an attorney while strictly adhering to the law and avoiding that bias. How do you do that?
Well, you can't get into making too many statements because then you don't want to get accused of providing legal advice. The hope is that in those instances that you're able to have the record reflect when the law does not provide discretion, right, to the judge to act upon feelings of what the judge prefers to happen based on the evidence and facts presented. And when I say what the judge prefers to happen, um, for many, it's important for them to recognize you as being a human being. And it's not always that there's a person on the other side that wins, and then that person that pro se litigant that you want to know, that you don't have the discretion to do what they're asking, because sometimes it's not an opposing party. It's well, I guess it's an opposing party, even if it's an entity, but it's not an individual. But if we have cases where, let's say, the cases that involve the state, the forfeiture cases, right?
Mm-hmm.
In where the party who's trying to get back something that they believe, the state shouldn't have, don't quite understand that there are a set of steps that must be taken, right? And there's a time frame for it to be taken. And then there's no discretion of the judge to say, oh, I'll give you more time, or oh, you can do this, or you can do that.
Mm-hmm.
Oh, that's not right. You should have this back. I mean, it's really yours. It's not the person who had it when the crime was, all that stuff, right?
Right.
Um, and so if there's a person there on the other side who can make the record right for the judge, and the judge will ask, and I've asked, so you're saying I have no discretion here, and then that lawyer, or even if it's a pro se litigant who knows what the law is, will cite what the law is, and then you're kind of laying it out, right, for the
Right.
party to hear, um, that there's no discretion, that I can't do anything. My hands are tied. And, so it's important for self-represented litigants, and all litigants for that matter, to understand that Superior Court is real. It's not television court. And a judge should not simply rule based on personal feelings, but is required to acknowledge and follow the law. There are many things that the law does not give us discretion to do. And it gets more difficult if you have, judges who are willing to ignore the law.
I mentioned this in my introduction, a couple things, and I'd like to touch on them. The first one I want to talk about is access to justice. Okay. I mean, if you think about it, that the Constitution of the United States is a fundamental right. Everyone has the right to access the courts for redress of their grievances, right? Okay. But what good is it if we don't promote and maximize the opportunity to have access to the court? And the failure for us to do it, or seize upon any type of technologies to do that, to what extent could we be breaching that constitutional mandate? And where I'm going with this is what you've done with virtual appearances. Okay. You've allowed litigants to appear virtually when, let's say, transportation or distance is a barrier. I like to know, and I know my listeners are going to want to know, what led you to adopt that approach?
Well, after going through the pandemic, when many times virtual was the only option for some participants, I met with attorneys, both criminal and civil attorneys, as well as prosecutors, and they asked that I maintain the option to appear virtually, giving them the right to choose whether to report to the courtroom or log on to the platform. And giving them that opportunity, then we want to give everybody, right, that same opportunity. And Georgia law permits it, and I found no basis to deny the request to continue providing it.
So, what did you see happening to people who couldn't physically make it to court?
Well, in addition to justice being delayed, potentially on the criminal side, they, bench warrants, bond forfeitures would sometime issue. But fortunately for the court team that worked in my division, they did work together. So whereas pre-pandemic, anytime there was a violation of probation would automatically submit a warrant. But during COVID and after COVID, that necessarily wasn't the case. And so they would consider the warrant, but sometimes they would schedule the person, sometimes they still do, of course, schedule the person to appear before they ask me to sign the warrant. So that cuts down, of course, on people being incarcerated, but the person could also appear virtually. And a lot of times, those folks, especially on those violations of probation, were out of state.
Mm.
They'd been displaced. Family potentially could have lost their home. They were looking for housing, and so they went to the nearest relative. And sometimes that nearest relative was out of state, right? And so providing that virtual platform gives them the option to still appear for court.
You just touched on something that is an outstanding question for me, and that is about outcomes. I mean, how does access to the court impact outcomes?
Oh man, in every way, in every way, it's important that we consider those we serve and not just our own conveniences. We also have, to consider those individuals we rely on to assist us with providing access to court because that affects the outcome. What we're seeing more and more in some areas are delays that could possibly be avoided with an option to appear virtually. We also know that a solely in-person appearance can be much more costly for certain types of cases. Before the pandemic, and I know I keep mentioning that, but that's the only reason we're here now to have this option. But before the pandemic, we had not considered how the virtual platform could provide options for those with the disabilities, whether permanent or temporary. Now, they also have an alternative. It's not perfect, and we find things to adjust as we move forward. But having the hybrid level of access certainly not only makes the court more efficient, but it also assists the lawyer with resolving conflicts. Think about that, resolving the conflicts with multiple court appearances, and gives them the ability to represent more clients in a shorter frame of time. When courts are having to hold for attorneys. And I know that you've had to do that in your career as a judge. The hold now for us may be 10 minutes, sometimes much less with the hybrid system. Instead of them calling saying, okay, I'm leaving Gwinnett. Based on the GPS, I should be there in an hour and a half. Instead, they're able to get in the car, log onto the platform, and we no longer have to hold for such a long period of time. All of that is before we get to all of those things, before we get to the money saved, right, by the state, the attorney, and their clients in scenarios where parties agree to virtual appearances of witnesses. And these are people who may have done absolutely nothing to be called in to be involved in the case, right? They get to stay at home, whatever state that may be. They get to go to work in most instances, and then can appear for the limited time we need them instead of having to fly them into our state, hold them for a day or two when they can't, potentially multitask and do some of those other things. I hope that answers the question.
Oh, it does. It does. And you made me think of as you were talking about the various ways of saving costs. I mean, not just regarding attorneys and like, I practice mostly civil law as a trial attorney. And, so we had a business to run and we charge by the hour. But when you're traveling, in metro Atlanta and I'm practicing in all those courts and I have a day like that with conflicts and I'm going from one court to the next court, I still got to get back to the office because I still have deadlines on other pleadings, answers to a complaint or a complaint that needs to be filed. So I don't miss the statute of limitations and so on and so on. You know what I'm talking about. And
Mm-hmm.
as a result, that interferes in my private life. It interferes in my marital life. It interferes in my parental life because now I'm coming home late, and there have been times I brought the kids to the office just so I can spend time with them.
Mm-hmm.
So I really appreciate, I wish I had that type of innovative thinking, okay, back in the day. Of course, back in the day when I was practicing, I'm an old man now, I guess, we didn't have that technology, but I really appreciate, Judge, that you, I'm going to put it this way, you're not a fuddy-duddy is as we used to say. Okay. You're a forward thinker and you're thinking about helping people and you're thinking about the cost. I mean, there's the human cost and then there's the financial cost.
That family component, it reminds me of the time when I do believe it was a defense attorney. He was in the car line. Of course, you can't drive while you're appearing virtually, and he
Mhm.
was sitting still. He wasn't moving, but he expressed an appreciation for the virtual option because he was able to pick his kids up from school. And that seemed to have brought him so much happiness, and it brought me the same. I was happy that he was able, to do that, because it was just answering. I believe it was calendar call, and so you're just telling everyone that I'm ready or I'm not ready, and how many witnesses I believe I have. That's
It's a
it.
great story. I mean, because you're right about for those who are not lawyers, counter call just you just appear in court and say you're ready or not ready, and maybe there might be a little issue here or there, but I mean, you probably you save that person miles and miles and miles in time of driving just to do that one simple thing
Yes.
that could have been done and was done. Okay, that way. But what do you see happening? Do you have maybe a story? You know, what you see happening to people who couldn't physically make it to court, or maybe they're struggling getting to court.
So that I've seen multiple things. One of the things that I know played a part in making sure we figured out how to continue this was when a young man said that he'd walked 4 miles to get to court, and that was why he was late. A bench warrant bond forfeiture had already issued, but we were still in court handling other matters. And I mean, it wasn't like 15, 20 minutes late. It was some hours late. And just to have that desire to keep coming, and you already know I'm not going to make it there, right? Potentially, he could have walked in the courtroom and been taken right into custody. And so, but I'm thankful on his behalf that we were still there doing other things. But the state recalled the bench warrant bond forfeiture. But what we learned from him is that he had to walk. I mean, obviously, he still wanted to get to court, but he didn't have any other means of transportation. And then for those of us, I mean, we may think, well, goodness, why didn't you just take the bus? But his statement was, I didn't have the money for the bus.
Yeah.
Okay, and so in my mind, how do I not work out a way for us to continue to provide the option? Because hopefully you have a phone or somebody's phone you can borrow if you don't have a computer, or an iPad, that you can log onto the system and be present. You just need audio and a camera. And we need to be able to identify you. So you need a first and a last name. And of course, you need to have the appearance of one who would be in the courtroom. You can't come laying in the bed or, walking around cooking breakfast or anything like that. You need to be able to be seated and appear as you would if you were physically, in the courtroom.
But I appreciate though, Judge. I mean, this really also comes down to one's character and value system and belief system. The fact that even when he did show up and it was late, because I grew up with a few judges around the state. Okay, and I say around the state because when I did practice law, I was contracted by the Attorney General's office, so I represented a number of state employees around the state and federal court and some state courts. But the bottom line is that the fact that you would take the time to get to instead of just simply handcuffing him and you ask what's going on. I know some judges who, in my time in this legal career, who wouldn't do it. Not warrants already issued, take him into custody. Okay,
Yeah.
why? I want to know what's it about you that you would take that moment to hear the rest of his story.
Yeah. So we've done it before, and it wasn't the explanation that I had to walk 4 miles. And people just show up late. And if we're there, what defense counsel knows that it belongs to the state, though. So if I've already ruled, it's good as done. I'm
Hmm.
just waiting on the paper. I've granted it already. Same thing is with a divorce. You've heard the hearing. You say, "Hey, I'm gonna grant that." You tell the lawyer, submit
Right.
it, submit it. As long as it's submitted as what you granted, then it's just signed off on. And sometimes you may not get it for a week, but if you ruled from the bench, then it can be not pro tunc to that day, right?
Right.
And so when they come in late, if we're still there, in my mind, there has to be some sort of reasonable explanation, right? Because it's not like it's next week; it's that day. So something happened, right?
Yeah.
And they were still trying to get there. And so I always, give them the opportunity, but I do let the defendant know it's not my call. I've granted it already. It will be my call if there's a motion to recall it, right? When it's
Hmm.
put back, when the ball is put back in my court. But it's probably that the prosecutors have been around and have worked on our particular team long enough to know that if the judge has to hear this next week, judge's going to grant it.
Yeah.
And so let me not be the prosecutor that keeps this person in jail for a week, knowing that the judge would grant this if the judge heard it, right? So
Right.
that's one perspective. But then also there are some prosecutors who would say, no, there's no way I'm going to have you go into custody. That's a reasonable explanation. Please, though, don't don't be late again. That sort of thing.
Right.
Yeah, yeah. But yeah, I'm going to always give them an opportunity to address it if we're still there.
So you've already talked about, in the case of the person who walked 4 miles, that I was going to ask you, is failing to appear always about irresponsibility? And the answer is no, because sometimes there are barriers. But I just wanted to ask the question anyway because you listen. It sounds like you at least listen to hear what that might be to determine whether it's a barrier or not. Is that safe? My statement.
I believe that's a safe statement.
Yeah.
Um, and it's important for us to provide that opportunity because a lot of times, folks will not disclose, right? That they're
Hmm.
facing difficulties. And what we know, though, is that people are facing them every day. And we have to speak up. We have to encourage folks to speak up. And we cannot assume that they can't assume that we're aware, and we cannot assume that others are aware of what they may be going through and the things that they have to deal with. Um, and so I think it's important for us to be cognizant of that. And we have lost, and I know this is a whole nother issue, but we've lost so many things and so many people because either we are not speaking up or they didn't speak up. We're not paying attention, right?
Hmm.
And so it's important more now than ever that we feel comfortable with speaking up and talking about whatever resource we may be lacking. Because otherwise, if we're not talking about it, then it does have the appearance of just simply being irresponsible. We
Mm-hmm.
need to we can't address the barriers if we're unaware.
Yeah. Yeah. Now, there's two other things I want to talk about before we end our conversation, Judge. There's another area of innovativeness in your work on the Parental Accountability Court. But before I ask you a specific question about it, okay, I want to establish a foundation about your work off the bench because parental accountability courts don't happen by just simply a mere issuing an edict and an order. Okay, so regarding this parental accountability court, and like I said before, I ask any questions directly related to this hybrid court. I want to focus on the role of the judge. Okay, uh, when it comes to working off the bench, I call it to create due process on steroids. Okay, um, how does that work, and why is that important? Because many of our listeners, especially those who are not familiar with judges, other than what we hear whether in the news or on TV or whatever, it's a common perception. All we do is sit on the bench, and that's all we do every day, in and out. And sure enough, that's most of what it is. But it's not always that way. If we want to make sure that we, you know, do some of the things that we need to do to make not only the administration of justice better, but our community safer. Can you talk about that?
Well, I believe it's important for folks to see that judges are actually a part of their community. And active involvement in community service organizations and events would do that, and it's necessary. While you have to be careful to make sure that citizens understand your role as a judge and what the judicial code, your governing authority requires of you. At the same time, being involved with your community lets them know that you too are human and not simply defined by the black robe. And I say all that, and I understand that some of our judges, depending on what they do or what they may have done, they may be a little bit more concerned, and we have to be, for safety. But there are ways to address that, because I know that for most of us, our sheriff's department or our police department don't mind being called upon to have a presence, whether it be known or unknown, so that we can be involved and get out in the community. So I don't want to, suggest that a judge can be out and be doing any and everything, because there's some things that we may be asked to do that we shouldn't do. But being present, for folks to know that you're human just like they are, I think it speaks volume.
So I want you now to describe, if you would please, the purpose and mission of the Parental Accountability Court. Okay. Um, but let's start maybe with you sharing, how does this accountability court model, redesigns the traditional punitive approach, into one that fosters better co-parenting and resource sharing?
Well, that's a good question. I love the Parental Accountability Court. And so while the custodial parent does not have to consent to the non-custodial parent's participation in the program, it does take a level of understanding from the custodial parent that the manner of child support enforcement is going to change. And hopefully that change is for the better, as the parent obligated to provide support seeks and receives resources that helps him or her with consistent compliance. Generally, that does lead, to better co-parents, better co-parenting and more meaningful parent-child relationships. After all, you cannot work and earn a paycheck while incarcerated. And so while I'm not the one explaining that to the custodial parent who's waiting on the support, I have heard the manner in which those who do have that discussion. Okay.
Hmm.
Because sometimes that custodial parent wants them to go to jail. They have it, they're paying everything else. They should pay their support, let them go to jail. But, there are different levels that have to be worked on when it comes to the court participation and the model that's instituted, particularly for my division.
Something just dawned on me, because you and I have had this conversation before, and you and the Superior Court judges, designated me as Superior Court judge to do the child support enforcement side of this, and then so you and I, in the beginning, when you created this Parental Accountability Court, you asked me to come over. We had a conversation. What would the relationship be like? And you educated me, is what I'm saying. Um, but now I'm also thinking about the accountability court, and one of the significant distinctions between what I was doing, which was just a matter of you come in. because you remember, Judge, it'd be like sometimes over 100 cases on a Wednesday morning, okay?
Mm-hmm.
You know, and you're just processing these cases.
Mm-hmm.
But what you're doing is you're getting into the lives of these people, okay?
Yes. Mm-hmm.
So I'm wondering if a lot of those parents, most of them are fathers, okay, but who come in to my child support enforcement and they're making statements like, "Well, why should I pay child support? I never get to visit with the child." Okay, stuff like that,
Mm-hmm.
right? Okay, but over in your court, it just dawned on me that you're creating the opportunity to help change the way that this father sees the framework here.
Yes.
Instead of it simply being, I don't get the visit, you know, it seems to me like you've created this 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 educational framework and in other ways to help reshape, or maybe let me just say there's a cognitive restructuring that gets him to the point that he's not feeling forced to pay, he wants to pay. Is that a safe statement?
It is a safe statement, and before we get into it too much, let me just go ahead and give credit to another set of judges in the state of Georgia in collaboration with the department that established, right, with the Department of Human Services, Division of Child Support Services, that established the program. And so there were some circuits who were doing the program before let's just say, chartered the Clayton Circuits
Mm-hmm.
program in 2016. So they already had this model in our state that I was able to bring to the Clayton Circuit, and so they should receive the credit for that.
Mm-hmm.
But certainly, so that the program itself fosters services or the provision of services to these non-custodial parents, and then they have to want to take advantage of them. Right. So it's a voluntary program. I tell them when they come on board, you're here because you want to be. If you don't want to do this, then you should, leave now, basically. And they do know that if they don't do what they're supposed to do, then they're gonna go back over to the other track. We're gonna make room for another person who wants to position themselves to be able to do better, right, and consistently provide full support for their child or for the children.
Can do you have an example of a parent who has gone through the parental accountability court and it's been a very positive outcome for not only for that person but for the child?
Yes, yes. And so there are many examples, but there's one in particular, and this particular non-custodial parent happened to have been the mother. And the child was, I do believe, a teenager at the point in which mom entered the program. There were various barriers, transportation. She didn't have a job, but she took advantage of every single resource that the coordinator afforded to her. She ended up getting a job, one that wasn't too far for her to walk to. It was a Burger King. And she went up the ranks in Burger King pretty fast. By the time she graduated, she was in management. I do believe she was an assistant manager. If she was a manager, she may call me if she hears this and be like, "Oh, I made it to manager." But she was definitely in management. And by the time she was, I believe probably about halfway through the program, definitely before she graduated, she was visiting with her child. And so many favorable outcomes from that participant. We actually went out and for lunch one day, myself, the coordinator, and a couple other folks, partners, and had lunch at the Burger King just to show her how much we supported her and believed in what she was doing, and provided some additional encouragement.
Right.
That she's one successful story. I mean, there are many. We've had you know, um, plenty of graduates with success stories.
You've given credit for those judges who preceded you in other circuits, but you chartered the one in Clayton County in 2016. Okay.
Mhm.
What was it? What inspired you to decide that this is what I want to do?
Well, two things. Um, I was one already when I was handling the contempt calendar, and as you said, it was before I became chief. One of the other chief judges came to all of us and was like, we think this is a good idea. At the time, the prosecutor at the time also came and was like, we're willing, let's do this if you guys are okay with it. And so you guys took it off of our hands, but before that, we would rotate it, right? Uh,
Mhm.
and I would always try and give that non custodial parent one more chance because I would always think this person is actually working. For the majority of them, were working. They
Mhm.
weren't providing the full support, or they would skip, a month here or there, and that's just not acceptable, right? But I knew that if I found them in willful contempt and locked them up, then potentially they wouldn't have the job at all. And so I would always try and give them one more chance. And most times they would pay the support with the threat of being locked up. But occasionally you'll have somebody come back that next month and hadn't done it and they would go to jail. And so I figured since I was of the mind to give them that one chance, right, that I would be a good judge to actually run the pack court. And Judge Collier, my chief judge at the time, also agreed with me. So those were the two things that led me to say, "Hey, let me do this. I believe I'm the right person or the right judge in the circuit for the job." And so here we are.
Wow. But Judge, I haven't experienced it myself, and I'm sure you definitely have, particularly in chartering and taking the leadership, uh, to bring the parental accountability court to the Clayton Judicial Circuit. That there are those out there that you know who push for that incarceration. I'm not talking about the moms, and understandably so, because they want the child support, and I feel for them absolutely. But I'm talking about just citizens. There's some out there that say you're lenient, okay, or they'll make that type of create that type of narrative. But you call this an accountability court, right? Okay, and sometimes people don't like being held accountable. So could you enlighten those out there that may not understand that re- repeated studies show that incarceration is as a default, that is okay, not that when it becomes necessary. I'm talking about as a default, that incarceration is generally not effective, and that there are better approaches to change a person's behavior and conduct, and that is what happens in accountability courts.
Well, look, I agree with all the research. I know that you're an expert in that area, especially when it comes to dealing with our juveniles, right? Um, but what I say to the folks who talk about about leniency and things of that nature, I say, well, yes. I mean, I'm not going to run from it. I'm not going to run from it. Yes, I've heard it, and I understand the perspective of the argument. But what you and I have seen, and the research shows that the outcome from using incarceration as a default is not what we're seeking.
Right.
Right. Is that we don't get what we want, from that. And I prefer to look at the best interest of the child when we're specifically talking about the PAC court and the obligation to take care, of your child. So I look at the child that's in need of the support as opposed to focusing on punishing the parent who is obligated to provide it. Since I found that the majority of mothers and fathers want to make sure that their children, are taken care of, I suppose we focus our efforts on providing resources that place the parent in a better position to do so.
Yeah, wouldn't you say though that what's really tough, some say, let's say on crime, or let's say on this, we're talking here about child support, okay, should really be measured by the outcome. That is there more child support being paid? Um, are there other positive outcomes as a result of the accountability court? And I take the mom who was the non-custodial parent, ended up getting a job at Burger King, then making management. And then as a result of the work in the accountability court, who was not having contact with the teenage daughter,
Mhm.
did end up having a relationship with the teenage daughter.
Yes.
It isn't, I mean, compared to Judge, if we were just incarcerating them, we'd actually have more children not getting child support because we'd be locking up the parents, putting them in jail, and losing their jobs.
Right. Exactly. Exactly.
So which one is the toughest one? It's the
Right.
accountability. Well, look, I want to shift real quick, come to a conclusion here. You're up for re-election this year. Is that right?
That's right. Hmm.
Okay. So, so here you were. You were campaigning in 2006. You became a Superior Court judge, I think, starting January 1st of 2007?
Yes, sir. Hmm.
Okay. So, and you were elected as the first African American Superior Court judge. That would also make you the first African American female court judge,
Hmm.
okay, in the circuit on a platform of unbiased justice. But looking at this reelection, how do you define experience that matters, that phrase, experience that matters in an era where, you know, court caseloads, you know, are climbing. There's instances of crime, increasing. It kind of goes up and down. But the people appearing before you come with so many life insecurities. How does experience that matters make a difference in for you, and why it's important for the population to first consider the person, the incumbent who's been there? What does that mean?
Yeah. So okay. So a couple of things. Let me say, because I don't want anybody to think that I'm misrepresenting anything in terms of being elected as the first African American. And you said it. Is Superior Court judge, and so there was another African American female elected to the Magistrate Court judge.
Right.
And actually, it was that person that I worked as the presiding magistrate for, and as a designated Superior Court judge, but the Superior Court judges do that appointment for any other judge, in the circuit who they have doing work for them.
Right.
So let me say that. But experience that matters in how I'm using it, how the campaign is using it, speaks to the doing of the job, right? This is the job that I've been doing for 20 years. At the end of this year, it would be a solid 20 as elected Superior Court judge, and a couple of years before that doing it by designation. But some of it, as I mentioned, I did by designation. It takes experience to effectively and efficiently do any job, right? Um, Coming from a background of judicial experience, of where the rubber meets the road, and that's what we call magistrate court, it was important to my elevation to Superior Court. It was there that I studied and learned the importance of the judicial code. And then in running the race, I reviewed it again because I understood that it applies even to the candidate, right?
Hmm.
And understanding that this level of accountability should not be taken lightly, and compassion for those with insecurities. We already have them in some shape or form, has its place, but an understanding that everyone, will be treated with fairness, and that justice will prevail even when one side of a case does not. is something that I have displayed for over 20 years, and it's most important. An unselfish, embrace of that principle from a history of judicial service is the experience that matters.
Well, Judge, I've worked with you very closely. Worked under you as the when you were Superior Court judge. We went through COVID together. You and the other Superior Court judges allowed me to be the Chief Juvenile Court judge. I was extremely impressed with how you handled that collaboratively, putting together a task force.
Who would have thought that I would spend my 4 year rotation
I know, right?
during COVID, right? Because it rotates for us. It's automatic. It's an
Uh,
automatic rotation every 4 years. And I got the COVID years. And
hmm
um, yeah, it was quite interesting. And I still have people who thank me and they're like, we're so grateful you had the COVID years.
No,
Okay.
and that's where I'm going with this, Judge. Okay, is exactly that statement. What others have said in thanking you that you had the COVID years because we met regularly under your leadership. I mean, you said we need to meet, we need to stay on top of this. And as things were coming up and we were having, cases of first impression and we were discussing that. But the point is that, experience that matter. And that's just yet one more experience you've had under your belt that I hope no other judge for a long, long, long time will ever
Right,
have to deal
right,
with,
right.
you know. But lastly, though, there's one other thing I want listeners to know about. I want you to talk about it. Okay, so you've done a lot. You've already mentioned about the presiding magistrate judge. Okay, all right. Now Superior Court judge for a long time, but you've done other things. You have served on the Judicial Council of Georgia. You've gone on also to hearing cases on the Supreme Court of Georgia by designation. In other words, you were a Supreme Court justice by designation, just as you had me be a Superior Court judge by designation to
Yeah, and they designate for one case.
Yeah,
So
that's right, one
yeah,
case.
they designate for one case. But
Yes,
I do
yes,
I do get to claim it.
right. But
Yeah.
they don't designate just anybody, okay? That's what I hear, the scuttlebutt I hear. And you've operated, quite frankly, at about every level of the system. Okay. Why is it vital for the citizens of Clayton County to maintain this level of veteran experience on the bench right now?
Well, as I look around and all that's going on, institutional knowledge is key right now.
Hmm.
We've had so many places lose it without leaving the roadmap behind, and so it's almost as if a lot of the partners are having to start over, and the folks that are served by the judiciary are the ones who suffer. When that happens,
Yeah.
and we see a little bit of that suffering going on as folks try and play catch up and learn some things that are critical. Um, So veteran experience, I think, in any arena is important. I'm sorry, but sometimes you can go, to a restaurant and they don't know how to prepare the items that have been on the menu for years because it's hard to find folks who know how to do the job. So we it's important.
Judge, I greatly appreciate you accepting my invitation to come on to the Teske Brief, to take this time to express publicly how much I enjoyed working with you. Is there anything else you want to say before we close?
Just thank you for having me. It's been good to interact with you, and I appreciate this. And I'm going to have to go back and take a look at some of the other podcasts that you have. Did not know that you were doing this, and this is just wonderful.
Oh, well, thank you. I appreciate that. To my listeners, thank you for listening. As I say, as I opened up and I closed in the justice system, right? Truth doesn't always come down to what people think. It comes down to what the law actually says and how policy puts that law into action. And so here on the Teske Brief today, we did something just a little bit different. We took a different twist or a different perspective. What we did different is all about sometimes the best way to understand how the law works and how policy actually works is to hear from the people who are applying it every day on the front lines of the justice system. And you heard that today in Judge Geronda Carter. All right, ladies and gentlemen, thank you very much for listening. All take care. Judge Carter, thank you again.